This morning, as you know, the Tobago House of Assembly proposes to discuss two bills. One, the Constitutional Amendment Bill, and two, the repeal and replacement of the Tobago House of Assembly Act. In the last couple of days, I'm quite sure that you all will be aware, there have been a number of letters going back and forth between the Chief Secretary and the Minority Leader. The thing for this was one, to try to get the Assembly to postpone and to look at the due process and to work along with the central government to arrive at a position that is unique and one that is acceptable to everyone in Trinidad and Tobago. Of course, as you well know, the Chief Secretary refused, and then and as a result of that, this morning we are about to do these two bills. We're going to draw something to your attention why it was necessary for us to do what we're proposing to do. I'm quite sure you're all aware that Bill number 1 is an act to amend the Constitution to provide the enactment of certain provisions related to Tobago House of Assembly and related matters. And the second bill is entitled an act to repeal and replace the Tobago House of Assembly Act 2503 to provide for the enactment of the Tobago House of Assembly to prescribe its power and function. Both bills are an act to repeal and replace, or the next one to amend the Constitution. The reason why I was having these discussions with the Chief Secretary is to stop the Assembly from embarrassing itself. And let me explain that to you. I want to turn to section 29 of the Tobago House of Assembly Act. And I will read section 1, 2, and 3, and 4, but section 4 in particular. Pardon me? 1996. Act number 40 of 1996. In the exercise of his power under this Act, the Assembly may propose and adopt bills in relation to matters which it is responsible for under the section 25. Such bills shall be described as should be debated in the Assembly in accordance with the standing order, and if adopted, shall be transmitted by the Chief Secretary to the Secretary of Cabinet with a request for its introduction into the Parliament for enactment into law in accordance with section 61 of the Constitution. 3. Upon the decision of the Cabinet to propose a bill so adopted shall be introduced into Parliament with the view of enacting in accordance with the relevant standing order. And 4, which is the most important that is related today, a bill adopted by the Assembly shall not seek to abrogate, suspend, repeal, alter, override, or be contrary to any written law in the Republic of Trinidad and Tobago, or impose a direct or indirect taxation. Let me just go over the bill again for you to show you how what is being done today is contrary to the very Tobago House of Assembly. 1. An act to repeal and replace the Tobago House of Assembly Act. The law says, section 25(9), a bill by the Assembly shall not seek to abrogate, suspend, repeal, alter, override, or be contrary to any written law. Secondly, an act to amend the Constitution. The same thing applies.
So what is the next move by the minority side?
With that in mind, the minority cannot participate in a debate that is contrary to the very act, very Tobago House of Assembly Act, which is contrary to the law.
So will you be going into the House?
Yes, and we will not participate in the debate based on the Tobago House of Assembly Act and the provisions made under section 29, particularly section 29.
How long did you discover that, Mr. Jack?
We have been looking at the act, and we have been discussing, as you well know, and we have been talking to the Chief Secretary back and forth about, let us not do this debate now. And there seems to have been a hard and fast position on it.
But we got the impression that 3 days ago?
Pardon me?
We got the impression that it's 3 days ago?
Yeah. And before that, we all remember the debate that took place at the 2 months ago when we said, listen, if the Attorney General said, let's talk. There's nothing wrong with talking. At the end of it, you will arrive at this position. But not only that, we have now put ourselves in a position where we will debate a bill that could do nothing based on the law. And if we were talking, we would have been able to come up with this position and address it. So we have now put ourselves in a corner where we will spend days debating a motion that is contrary to the very act in which we are governed.
And you drew that to the attention of the Chief Secretary in your letter?
No, I did not. In fact, you know the Chief Secretary like to boast of his battery of lawyers. This is the responsibility of the battery of lawyers.
I see.
That is why you hire legal counsel. And that is why I was saying, let's talk. If we had spoken, we could have arrived at all these positions and would have found a way out that is amenable to all of us, that is legal, and something that could have allowed us to be able to discuss this, maybe as a motion, not necessarily as a bill, saying, look, or we could have met in camera, discuss this matter, have a to-be-go position, and request of the cabinet that these things be done based on the law.
Well, finally, based on what you're saying to us, this entire matter of dealing with T.I.C.N constitutional review as it relates to Tobago lies purely in the hands of the cabinet and the parliament.
Unfortunate but true.
Okay. Thank you.
Unfortunate but very true.